Hi, my name is Damian Schiff and I'm an attorney at Pacific Legal Foundation. I'm here to talk about a case in which we recently filed an amicus brief for the United States Supreme Court called Grand County Irrigation District. This case arises out of Washington State and it deals with a couple of water districts who are suing the federal government for a taking of their water contract rights. Now, why, you might ask, does this matter for folks outside of Washington State? Well, it matters because the type of water contract that these water districts have in Washington State is pretty much the same type of contract that water districts have throughout the western United States, including some very important water districts here in California. So on account of that reason, on account of the impact that this case is going to have, we at PLF filed an amicus brief in support of the water districts in Washington State on behalf of water districts here in California. Westlands Water District, San Luis Water District, and San Luis and Delta Mendota Water Authority. Now combined, these three California water districts service hundreds of thousands of folks here in the Central Valley and parts of Southern California, providing industrial, municipal, agricultural water. The issue in the case that may be before the Supreme Court is how to interpret these water contracts. Are they water contracts that provide a real right to the water users, a right that they can use as against other folks who might try to take that right away from them, a right that has value, that if taken merits compensation, or is it instead simply a contract right that if taken away provides no compensation to the water contract holders? That's the issue, and the federal government has taken the position that these water contract holders are simply water utility customers, meaning they pay a monthly fee, but that's all that they get. They get the water that they pay for, nothing else. Even though people who have these water contracts, water districts here in California, Washington State, and other places, even though when they pay their fee, they're not just paying for the water. Rather, they're also paying for the cost of building the water structures, for building the canals and the aqueducts and the reservoirs. And so they're paying basically for stuff that the feds are saying they're never going to get. That's just unjust, it's flat out wrong. That's one reason why the water districts in Washington State are seeking review of an adverse decision in the U.S. Supreme Court, and that's one reason why we at PLF filed a brief in support of them, urging the Supreme Court to take up this case to bring justice back to water rights here in California throughout the West, fighting for a safe, secure, reliable supply of water throughout the West and here in California. If you want to know more, though, about this case and other water rights and other property rights cases we're dealing with in Pacific Legal Foundation, I'd encourage you to visit our website, pacificlegal.org, and also our blog, our Liberty blog, plf.typepad.com.
For more PLF videos, visit our YouTube channel.